So we'll go ahead and take the roll and get started.
Senator Crago,
Here.
Senator Crum,
Here.
Senator Hicks,
Excused.
Senator Kolb,
Excused.
Chairman Olson.
Okay.
You have a
Thank you.
quorum.
Oh, sorry. Thank you. The first Senate file for our consideration is Senate File 8, Protection Orders Effective During Appeal or Review. And I know we had a representative, was it Representative Rodriguez-Williams who brought this bill to the committee? Senator Crago, do you remember?
Mr. Chairman, I actually don't remember who brought this forward. It may have been the representative. I cannot remember off the top of my head.
Okay, well, I was hoping she would be here to walk us through the bill, but that's okay, that she's not. We'll go to our state agencies who can do just the same.
Good morning, Chairman. My name is Kara Chambers, and I'm the Director of the Division of Victim Services within the Attorney General's Office. My recollection is that it was Representative Rodriguez-Williams. I believe because this was, in my world, a very notable case out of Park County where this did not happen. I believe this bill is an attempt to clarify procedure. And with that, I'm happy to stand for questions. It's fairly, I think
And
you
so
guys like to say a simple little bill.
It is very simple. So the bill specifies that during a protection order that's granted under 7-3506 through 73512, it remains in effect during the pendency of any appeal or review or any decision to modify or extend the order of protection unless a court orders a stay during the pendency of the appeal or review. And so it deals with Title VII, which I forget which type of protection order goes under which statute. Title VII, is that the domestic violence? That's the
Chairman, that's the
Stalking.
stalking and sexual assault. And then
stalking and sexual assault, and then we amend Title 35, which is domestic
Yes, sir.
violence, with the same amendment just to that title.
Yes, sir.
Okay. Any questions for Ms. Chambers? No? All right, thank you. Do we have anyone who wants to give public testimony on this bill? Online, we have one person signed up to give testimony. Ms. Petterman, go ahead and admit her. Welcome, Lisa. Maybe. If you can hear us, go ahead and light up your mic and your camera. There you go. Introduce yourself and then tell us what you want us to know.
Mr. Chairman, good afternoon. My name is Lisa Peterman, and I'm the Executive Director of Crisis Intervention Services. We're the domestic violence sexual assault agency here in Park County. I've been in this position for the last 25 years. Prior to coming to Park County, I was director of the Johnson County Family Crisis Center for 10 years. I'm testifying today in support of this Senate File 8. Ensuring that protection orders remain in place while under appeal is critical to keeping crime victims safe. Our law enforcement need every tool at their disposal to enforce these orders because we have a loophole. This particular flaw in our protection order process became glaringly apparent in Park County. A victim of stalking had a 6-month protection order. The perpetrator appealed that order. As this order was under appeal and set to expire, the victim in the case filed for an extension. As the original case was under appeal, Park County law enforcement then had questions as to whether or not the extension was enforceable. You may have heard of this case as it was featured in Cowboy State Daily News and reported that when law enforcement was able to obtain a search warrant of the perpetrator's property, they found several firearms and 2 pipe bombs. So I would respectfully request that you move Senate File 8 forward through the legislative process. We have a loophole in our protection order statutes, And Senate File 8 is a very simple fix to this problem. And I'd like to thank you for giving me this time. Thank you for all your past support of Wyoming domestic violence sexual assault agencies in Wyoming over the last 35 years that I've been doing this work.
Thank you, Ms. Peterman. Appreciate you giving us that background. As with the exception of Senator Crago, the rest of us are all brand new to this committee, so we're seeing this bill under testimony for the first time, so it is helpful to have that background information. Do we have any questions for Ms. Peterman? Senator Hicks.
Mr. Chairman, not for Mrs. Peterman, but for
Oh.
maybe some of our legal professionals.
Okay. We'll close with Ms. Peterman. Is there any other public testimony? I don't think there is. So do you, Senator Hicks, want to ask your question? We'll see if we can find someone who can address it.
Yeah, so Mr. Chairman, if we go to the short title, it talks about applicability for stalking, sexual assault, and domestic violence protection. So we go into Title 7 and Title 35. I'm assuming, I'm trying to find it, under Title 35, that includes both stalking or sexual assault and domestic violence under Title 35.
Title 7 is sexual assault and stalking. And
Oh,
Title
so
30
those two are combined under Title 7.
Yep, and then Title 35 is just domestic violence.
All right, that's what I wanted to find out. Thank you.
That was it? That was easy. I'll send you a bill.
Good luck.
All right.
Hope you got a good attorney.
All right, I officially close public testimony. Committee, what is your pleasure with this bill?
Move the bill.
Senate File 8 has been moved by Senator Hicks. We had a little bit of discussion on this bill. Is there any other discussion on this bill or amendments to this bill?
No.
All right, then let's do a roll call vote on Senate File 8.
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Excused.
Chairman Olson,
Aye.
4 ayes, 1 excused.
And Senator Kolb didn't know it, but he volunteered to present this bill to the floor. So, all right. Senator Hicks.
I would be willing to do that in lieu of Senator Kolb.
Okay.
Because as I talked to you earlier, I've got another committee meeting that doesn't, probably gonna have a quorum over there that I need to step out on, and so.
You picked the easiest one of the interim bills. You can tell you've been here for a while. Thank you, Senator Hicks. Okay, sounds good. Public and committee, what I'm going to do is based on what I assume to be kind of testimony and committee pleasure on working through the bills. I think there's gonna be a little more testimony and work needed on Senate File 9. So what I want to do is actually, I'm going to change the order of the bills, and I'm gonna take up Senate File 39 next, because I think it's gonna be a little bit lighter lift, and that way we have some leeway with Senate File 9. It's possible we're contemplating some amendments to Senate File 9, and we're not sure if we're gonna have those together and in order now during this meeting, or whether we're gonna need to carry the bill over to another meeting and give us enough time to work the amendments. We'll see how that goes through public testimony and so forth. So I'm just giving you a heads up on why I'm doing that. And with that, we'll take up Senate File 39. This is my bill, so I'm going to turn the meeting over to Senator Crago. I will present the bill, and then for the remainder of the bill, Senator Crago, I'll just have you conduct the meeting. And if you don't mind, Mr. Chairman, if I could just present the bill from right here, I feel much more comfortable.
Please proceed.
Okay, all right. This is Senate File 39, automatic transfer of automobile title upon death. I probably should have worked the title a little better. The title's a little deceptive. I've had people ask me, so does this just automatically happen upon death? And the answer is actually no, it doesn't. There is some administrative steps that have to take place, so the title is a little bit confusing, but the genesis of this legislation comes from the a law that was statute that we have in Wyoming called a transfer on death deed statute. And so I think that's been in effect since 2013. And what that what that statute allows someone to do is add a beneficiary to their real property. So that beneficiary could be anyone in the world, and it doesn't give the beneficiary a vested current interest in the property. So they're not an actual owner of the property, they're just a beneficiary of it. And so the idea is exactly the same here, but with auto titles, is to create a system where we can add a beneficiary to an auto title and pass that property without the need of probate or court supervision. You can already do that to some extent if you're listing someone as a joint owner. But again, the idea here is to not list someone as a joint owner. This might be the scenario where, for example, you want to pass your vehicle to your children, but you don't want to make them a title holder of the property during your lifetime, because you invite all types of risk in when you do that. Your child might file for divorce, they might file for bankruptcy, they might run over a motorcyclist and get a judgment against them. There's all kinds of things that can happen to them that would subject your property to court proceedings. And so to avoid that, you would like to have a system maybe where you can just list them as a beneficiary. And the last thing I'll say before I walk through the bill, Mr. Chairman, is I face this pretty regularly as an attorney, where someone will come to me with a title after their father or their mother has died, and the vehicle is only worth like $500. And they're trying to get the title out of the deceased's name and into their name. And the struggle is, if it's worth less than $200,000, it's not subject to probate, but it still has an administrative process where you have to create what's called an affidavit of collection and distribution, sign it and record it in real estate and then take that into the title office and move title. So sometimes the affidavit is something that a person can manage on their own. Other times they need an attorney to help prepare that affidavit. And the attorney is likely going to charge more than what the vehicle is worth to prepare that affidavit. So it becomes a very difficult process for someone with very little property to go through that administrative process. The cost sometimes outweighs it. So the idea again here is just to make things a lot simpler for people. Of course, it doesn't have to apply to a $500 vehicle. It can apply to any vehicle, but those are the main reasons why I brought the legislation. And with that, Mr. Chairman, I'll just briefly walk through the bill.
That would be great. Thank you.
Okay. On page 1, section 1, we create a new statute. That's the transfer of title upon death beneficiary designation form statute. So the key thing to remember about this legislation is that you're not actually, by listing a beneficiary, you make no actual change to the title itself. You just create that through the designation form. The form is supposed to be, I believe, created by the Department of Transportation and provided to the county clerks. And then that form should be made available to anyone wishing to utilize this statute. On the form, they have to include certain information that's on page 2. That's the basic information about the vehicle, the name of the owners of the vehicle. The words transfer on death to so-and-so must be on the form, and then a signature of the owners, because they're the ones who are, of course, giving the authority to transfer upon death. So that's where it starts, is with a form. Bottom of page 2, subsection B tells us what happens upon death, and that is the beneficiary shall present the form to the county clerk and request a new certificate of title. They present the form, present a death certificate, and then they get a new title. They pay the fee for the title, and then they get it. The title will be issued in their name. Page 3 talks about what the clerk wants to see, which is the proof of death, which would be the death certificate, and then the fee, of course, set by 31.3.102. The bottom of page 3 is important. It talks about liens. Something that's important to note is that the transfer of the title is subject to any liens and security interests. So when the new certificate of title to the beneficiary is issued, any liens that existed prior will travel with them to the new title. Page 4, during the lifetime of the owner of a vehicle for which a beneficiary designation form has been properly executed or before the death of this last surviving owner, such a vehicle must have the signature or consent of the beneficiary. I'm sorry, the signature or consent of the beneficiary is not required for the transaction. Only the signature of the owners is required. And then bottom of page 4 tells us that the owner or owners of the vehicle can revoke this beneficiary designation at any point in time. Page 5, middle of the page, subsection G, we have again the discussion of the lien. This language is a little broader, and it says that the interest of the beneficiary in the vehicle is subject to any contract of sale, assignment, lien, ownership of security interest to which the deceased owner or owners were subject. Bottom of page 5 just tells us that a will, if you can't affect it, which that's the case with the beneficiary deed as well. You could have a will that wills away your property, bequeaths your property to whoever, but if the title is going to trump if you've listed a beneficiary on the title. That's the same way we deal with our house transfer on death deed as well. Page 6, we have definitions. Bottom of page 6, after the definitions is section 2. This is where we amend existing language. Page 7, all we're adding is that the department, which is the Department of Transportation, shall provide at cost suitable certificate of title forms and beneficiary designation forms to county clerks. So I mentioned that earlier, but that's where the form comes from anyway. And by the way, I should mention, Mr. Chairman, the form shouldn't be terribly difficult to create, and I can't remember if I think it's 21 states that have this law in effect. It's pretty common in the United States, so coming up with a form should be fairly easy. I should have mentioned this at the onset, but this statute was lifted from Colorado. So this is verbatim what was used in the state of Colorado. Bottom of page 7, transfer of ownership, just a slight amendment to add the new statute that we've created. That's 31-2-104.1. Carrying over to page 8, existing language, and you can see where we insert the new statute again. Page 9, existing language. Page 10, section 3 is rulemaking authority for the Department of Transportation, and section 4, Mr. Chairman, is that it goes into effect July 1st, 2025. With that, Mr. Chairman, I will take any questions.
Senator Crum, do you have any questions for the sponsor?
Thank you, Mr. Chairman. Just a couple questions. I do appreciate what this bill's trying to do to make it simpler. My concerns have to do with the transfer of ownership when there's a lien on the title. A couple things. Many notes, it varies by institution, but a lot of times there's a payable upon death when a person pays that note. So that note's now matured in full. So, they're going to looking for, to collect full payments. So just a question on how that's going to be handled. I see Mr. Myers here from the Wyoming Bankers Association. Maybe he can answer that question. The other one is the credit worthiness of the new owner of the vehicle. The deceased may have been very creditworthy and able to pay the loan, but then if the loan is still in force, the new person may not be creditworthy, and you've just caused a problem for the lending institution of having to try to find and repossess a vehicle at that point in time. So just a couple questions how we would handle that lien with financial institutions on a uncreditworthy borrower or as it relates to the payable on death clauses.
Senator Olson.
Thank you, Mr. Chairman. Senator Crum, great questions. I will start by saying again, the law is crafted after basically modeled language from Colorado. And, you know, that statute's been around in Colorado long enough that I think they've been able to work through probably some of the issues that you've raised. So I imagine it's not terribly difficult. As far as the first question goes with the liens, Mr. Meyer and I have been talking about that, and I tasked him with coming up with some language. He does have an amendment that he'll distribute to us, and it's modeled after the language from the transfer on death deed statute. So we're trying to address that lien issue, and I think you'll like the model language. I think it will help a lot to alleviate any concerns you might have. The creditworthiness is an excellent question. I haven't considered that, and in the legislation, there is not a provision that would address that. I certainly welcome any input on that or any amendment necessary to cover it, but I really hadn't contemplated that scenario, Senator Crum.
Follow up?
Mr. Chairman, no, I appreciate the clarifications and answers. I would like, if Mr. Meyer testifies, I'd like to hear his thoughts on it, but I very much appreciate it. Thank you.
We can do that.
All right, Senator Olson, I had a couple questions.
Okay.
One, on the form that requires the signature of all owners on the vehicle. Is that a simple signature or a notarized or verified signature? On page 2. That's my first question.
Mr. Chairman, great question. The statute says a signature of owners, so I would say that it wouldn't require a notary, but it should require a notary. So I think that would be a really good amendment.
And then my next question, and just so the public kind of understands, walk us through how this actually works in practice. So an owner of a car wants to name a beneficiary, they fill out the form, then what happens to that form? Does the form go to the clerks right away? Does the form not go to the clerks till after death? Is there a notation on the current title? Just walk us through so we're all on the same page on that, maybe.
Thank you, Mr. Chairman, for that question. So under the statute, what it would look like is a person would go and get a copy of the form, they would fill it out, they would sign it, and then they would keep it with their legal documents privately. The statute doesn't have a requirement that it be deposited with the clerk. And I guess there's pluses and minuses to that. When I read the original statute and contemplated that exact question, I thought that what I wanted to do was have a statute that is as easy for the clerks to administer as possible, because I didn't want to create an administrative burden. So I thought we would leave that alone. As a practitioner, I can tell you that what I would probably do is I would probably have it recorded. So I would go down to the real estate office in my county. I would instruct my client, if I was working with them, to have it recorded. That could be something that we could require in statute. So then there's kind of a depository there. You've got the signed version, it's recorded, we know where it's at. We know that must be the original. You could do something like that if you didn't want to create that extra administrative burden for the clerks.
Thank you, Senator. Any further questions? Senator Crum, you're not going to ask yourself any questions, so I think we'll move on to if there's any agency testimony or any testimony from our county clerks, I'd love to start with that. Please introduce yourself and tell us what we need to know.
Good afternoon, Mr. Chairman. I'm Mary Lankford, and I have the honor of representing Wyoming's county clerks. And we're glad to be able to speak on this piece of legislation today. I have to tell you that the first comment I got from the clerks is, I was supposed to get the vehicle. And we hear that often when there's a death or a vehicle, a situation like this comes up. So it's not really uncommon. But I also want to reiterate some of the questions that you committee members posed also. The first question that I have, or the first comment I have, is on page 2, line 15, again, where should the form be notarized? And if it's notarized, then it's recordable. And maybe recording it would be the optimal thing to do with that form. Because the other concern that I have is that if you decide that you're gonna make your favorite son your beneficiary today, and in 5 years, your favorite son isn't your favorite son anymore, and you decide that you're gonna make your favorite daughter your beneficiary, and so there are a number of these documents that get generated. And over time, because this could be something that would be happening imminently, but it could be something that doesn't happen for 20 years. So at the point that the owners of the vehicles or owner of the vehicle passes, how do you know, how's the clerk gonna know she's got the right form? So if there's been 4 forms generated, and the first form guy shows up first, and there's a title generated on the first form, but the 4th person is really truly the beneficiary. So that's one of the concerns that we have is that how do you make sure you've got the right beneficiary at the end? So again, if it was a document that was recorded, then it would stop that time and make the real person that person. I think that would be a good amendment to the bill. We are also concerned about the lien. And one of the other things I just thought about as you were discussing too is thinking about Wyoming titles. Well, we deal with Wyoming titles all the time. But what if the title that comes with this beneficiary form is not from your county? That lien is filed in another county as opposed to your county. So you'd have to track that down and work with that county to get the lien fixed on the new title. What if it's an out-of-state title? That's a whole new bailiwick that comes with the beneficiary form. So a couple other things to consider as you go through this. I think we all agree that there's a lot of those $500 junkers out there that you could spend $2,000 getting title to a $500 junker, but it could be a '66 Mustang too, or a $100,000 four-wheel drive pickup. So it's important to get that right. We are happy and willing to work with YDOT to generate the form, and we see that form is not going to be a chargeable form or a chargeable type of an event, so we wouldn't need a fee because the bill or the law kind of contemplates when it talks about that YDOT provides vehicle titles to the county clerks, and the clerks have to pay for those vehicle titles. This would be a form that we wouldn't have to pay for. It'd be a PDF and probably would be readily available, much like a bill of sale form or something like that. So, and with that, Mr. Chairman and committee, I don't think I have anything else to provide or to question. Would be happy to take any of your questions, and thanks for the opportunity today.
Thanks for being here, Mary. Committee, do we have any questions for Ms. Langford? Senator Crum.
No, just a quick question. Do you have a solution on this, Mr. Chairman? Is there a solution on the number of documents? You know, you say up to 4 of these affidavits being filed. Do you have a solution on how to make sure that which one's the correct one?
Ms. Langford.
Mr. Chairman, Senator Crum, not really, except for I think that the recording option is probably the correct answer because it would be a public record, that beneficiary form, as opposed to handing it off to your favorite son and saying, here you go. I'm concerned about that because those things happen. People change their minds. And it could even also be if their vehicle's owned by two people, one person could pass and you still have the other person and they're like, hey, I never could agree with him, so I'm gonna give this vehicle to somebody else, you know? So, but I think recording might be the best solution because it does make it a public record that way. So.
Anything else for the county clerks? All right, thank you. Do we have any other public testimony in the?
Thank you.
Yes, thank you. Any other public testimony in the room? Mr. Meyer?
Good afternoon, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. Knowing full well of the power that our county clerks have, I don't know if you have one online or not that you want to hear from before you want to hear from me. Very good. I find myself in a rather unique position in the fact that after practicing almost 30 years, I really like the idea that the bringer of the bill has to make this simple and welcome it. But when I switch hats and I look at it, I do think that there are some questions I have regarding some of the stuff that Senator Crum brought up too regarding the liens. So I'm trying to figure out how we do this the best way to make sure that this bill gets all the attention it needs and gets passed. One of the things that I noticed when you look at the transfer on death deed is that there's an introductory paragraph. And so I've kind of written up something that I thought might be good that we could put in as a new paragraph A that basically just kind of goes through as an introductory that this is subject to the liens. And I think that that kind of lays the groundwork of what we're trying to do. The other issue that we ran into when we did the transfer on death deeds was what happens with insurance. And so I've added it on the back side. I put it on two sides, but on the back page, the back of the page is some language I took out of the transfer on death deed to say, look, the insurance will be on there for 30 days, 60 days, whatever the committee wants, but at least to make sure that that vehicle is covered. I think for the beneficiary's benefit and for everybody that's there, but more for me is to make sure the lenders know that that vehicle is covered, at least for the time being. And so I think those are the couple areas that I want. One of the things that I want to address, Mr. Chairman, and it was a question that was brought up by Senator Crum. You know, the idea is that I think he's right that when the financial institution lends, they're making sure that that person is there, that is creditworthy, is somebody that they can do business with. With that person gone, we don't know who this next person is. And so I think it's important, when you look at the security agreement, usually in those kind of situations, kind of like a mortgage, but also with a lien, those things become due as soon as there's a passing. Now, the financial institution will definitely take note every day of what's in the paper or what's online. They do make sure that they cover their bases the best they can. But I think it would be great if we could have some kind of like, that was just discussed about recording that beneficiary statement, this transfer on death title, and perhaps providing everybody who is on a lien on that notice of that. Now you have that being recorded, but I'm not sure every financial institution wants to go down and make sure they check the county records. But if they did one of these where they filled out the form, it was recorded that if it was also required to be sent to the lien holder, the lien holder then would have some idea of what's going on and what to watch for, just so that they know that. Other than that, I'm trying to think if there's any other questions or that was brought up. I definitely think that that form needs to be notarized. That way we know the order of what has priority with respect to any other forms up there. But other than that, I'm just trying to help, and I'd stand for any questions.
Eddie, questions? Senator Crum?
Yes, Mr. Chairman. A question of clarification. So the current borrower passes away, we transfer the title over to the beneficiary. And the lien's still in place. We figured that problem out. But then the question to me is, who's the borrower? Because just because the lien's in place doesn't mean the beneficiary became the borrower. So who is obligated to pay that lien would be a question I would have.
Mr. Meyer?
Mr. Chairman, Senator Crum, I think that the way that works is that the borrower switches from the decedent to the decedent's estate. That's why there would have to be, there's usually language in the security agreement that says this becomes due now. This is not unusual that I see people that they take that vehicle and they just keep making payments, which makes everybody happy, but it's not right. But they make payments until they quit, and then you got a problem. So it is important that the lien holder know exactly who is making the payments and, you know, as of the date of death. They're usually pretty, my experience has been most of the lien holders are pretty easy to work with, whether it's a transfer on death type thing or whether it's a probate or summary distribution for a couple of months if they know that you're making progress. But if you just don't see anything happen, then they can exercise their rights and even force a probate if they had to.
Follow up? Senator Olson?
Thank you, Mr. Chairman. I was just thinking about your amendments and trying to figure out where the best place is to have them. You have them in the probate code, and maybe that is the best place. Or we could add them to this new statute 31, so everything's in the same place. Maybe that's not the best thing to do. I don't know. Or do you have an opinion one way or the other?
Mr. Chairman, Chairman Olson, I struggle with that as I was looking at it. I thought, well, we can just add a new paragraph A and have the preamble language and then add something at the very end. But you're right, the transfer on death deed is in the probate code, and that's maybe the better place to put this. It's definitely needed, but I don't know which one is the better. I can flip a coin.
Okay.
Follow up?
Then it'll be up to us to sort that out, so
Right.
we'll figure it out.
All right, any additional questions for Mr. Meyer and the bankers? Thank you for being here today. Thanks for the help.
Thank you, Mr. Chairman.
Any additional public comment in the room? All right, how about online, Pierre? All right, thank you. With that, we'll close public testimony. Committee, what's your pleasure?
I'd make a motion to approve the bill.
All right, committee,
Yeah, amendments.
let's work the bill.
I think, the first amendment would be on page 2. Line 15. I want to add the notary, but it could probably be just as simple as saying the notarized signature of all owners of the vehicle. That's, so insert notarized between the and signature.
Seems like a good option. Any
Yep.
discussion on that? All in favor, say aye.
Aye.
All right, that amendment has been adopted.
I think right in that, I want to add the recorded requirement. Maybe the best way to do this would be to create a new subsection B immediately after the form. And this new subsection B on line 17 would read, the form shall be recorded in the office of the county clerk. Period. It's a little bit tricky. In the transfer on death statute, we say in the county where the property is situated. I mean, we still could do that with a vehicle, I suppose, or they're registered by county. So maybe we could say the form shall be recorded in the office of the county clerk in the county where the vehicle is titled.
And then Senator Olson, would we just get rid of the,
And then you mean, what are you gonna ask about this current? No, we need to keep that, so we'll just move subsection B to subsection C. and so
Renumber.
forth. Renumber accordingly.
All right, so your motion would be to create a new subparagraph B that says the form shall be recorded in the county where the vehicle is registered. Got it?
Yep.
Any discussion on that? Seeing none, all in favor, please say aye.
Aye.
Aye. All right, that amendment has been adopted as well.
Okay. And then,
Mr. Chairman,
go ahead, Senator Crum.
would it be best interest, just everything then else becomes B becomes C, C becomes D?
Yes.
Do we need to move that or no? It just,
Nope, LSO will automatically do that.
So,
okay, thank you.
Senator Olson, one question about paragraph B, though. It says, upon the death of the owner, the last surviving owner of a vehicle for which a beneficiary designation form has been properly executed.
And recorded.
And, right, so we probably need to add that. Beneficiary shall present the form to the county clerk.
Mhm.
Do we need to add the language "and recorded" in that particular section?
Well, I think that amendment should definitely add it to line 19, properly executed and recorded before the comma. The beneficiary shall present the form to the county clerk. You're saying the beneficiary shall present the recorded form? Yeah, add recorded before form. Did you get that?
So
Oh.
line 19, after the word executed, it would be "and recorded." And then line 21, between "the" and "form," you would add the word "recorded." All right, any discussion on that additional amendment? Senator Crum?
Mr. Chairman, I don't know if it goes here or not, but just to ease the county clerk's thing, which form is appropriate? You know, we talked about one, up to 4 forms. Would it be, to help them out, the last form filed prior to death is the appropriate one? How do we determine, you know, which of these 3 forms or 4 forms that are filed, which one is the correct one? The last one filed, the date that the person signed it, and then filing date really doesn't matter, although it has to be filed? Just a question I have, Mr. Chairman.
Yeah, Senator Crum, I think you could put language in here if you wanted to, but I think naturally and legally, it's already gonna be the most recently dated instrument, because that's how we deal with all instruments that are recorded. Whatever the most recent one is the one that's going to apply to the situation. But like if you were to record deeds, for example, if you were to record a will, we don't record wills in Wyoming necessarily, but a will, you look at the most recently dated will versus older versions.
We'll phone a friend. Thank you, Mary.
Mr. Chairman, that's exactly right. But I'm having a little question about something a little earlier. In your new section B, where you say the form shall be recorded in the county where the vehicle is registered,
Mhm.
you want that to be titled.
I thought that's what we said. Did we not?
Titled? Is it titled? Okay. Because registration is the plates. We don't care about the plates. We want the title is the, okay,
Okay.
I
perfect, thank you.
think, just for clarity, I think I did use the word registered, but I believe Chairman Olson used the word titled. So
We're all on.
as long as staff has it right, we're in good shape. So, thank you.
Okay. Thank you.
Mr. Chairman,
Go ahead, Senator Crum.
would it help, or it doesn't matter, for the county clerks to make a specific which one is there, or if just normal course of business is gonna be, you're gonna know which filing is correct to this form?
Mr. Chairman, Senator Crum will know that the most current filing is the appropriate one.
Thank you.
To this,
Stay tuned, Ms. Langford. We might need your help some more, so. Stay a little bit closer. All right, Senator Olson.
Yeah, Mr. Chairman, I want to move to add the, is this a new, Scott, is this a new statute? 218-103A, or where did you put that? Are you amending a statute?
That's the language that came from.
It came from the transfer on death deed statute, but I haven't looked up the statute on where you're placing this.
Come on up, Mr. Meyer, so everybody out in the rest of the world can hear you, please.
Thank you. Chairman Olson, I just copied that from the transfer on death deed and thought if we had something like that as the preamble, to make sure everybody knew about the fact that the lien follows. And I changed the language. Everywhere it said deed, I changed it to title.
Okay, so we don't want that statute because that statute is the
No.
transfer on death deed
And-
statute.
That's just where I got it.
And I might make a suggestion, Mr. Chairman, that maybe I think all of us agree that we probably want to do these two amendments, but we might just spend a little time between now and committee of the whole and figure out exactly where we want to put them. I'm happy to bring a committee of the whole amendment with you if you so
Right.
desire, so that we know exactly how to number and where to put it, get the language exactly right. Because I think it's a good idea. I think we're all supportive of it. The whole committee can be here.
Or maybe we can just try this, we can just give staff latitude to plug it in
That would be
where
fine
it
as well.
goes. And they can come to us. So I'll move, both amendments here given to us by the bankers.
So the motion is to have conceptual amendment drawn up for both pages of the amendment provided to us by the bankers. Any comment or suggestions on that? Senator Crum?
No comment.
Senator Olson, anything else? Any
Yes.
discussion on that?
Oh, on that, no.
All right, so all in favor of the conceptual amendment? Yes, Pierre? It does, yes, sir. All right, so seeing no further discussion on that, all in favor, please say aye.
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 All right, that amendment has been adopted as well. All right, next amendment.
I think the last amendment, I can't work entirely out on the fly. But, so maybe this will be something we work and bring on a reading, but I like the idea that a grantee beneficiary has to provide notice to the lien holders when they take possession of a property through the form. So I don't know where it goes, and I don't know exactly what the language should be, but I think we need it. So something we can work on. I can work on.
Yeah, and I'm happy to help you do that, Mr. Chairman.
Other than that, that's all I have.
All right, anything else? Senator Crum?
No.
All right. Pierre, roll call, please.
Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks.
Excused.
Did he leave a vote sheet with you?
Oh, yes, excuse me. He left an absentee vote of aye. Senator Kolb
Excused.
and Chairman Olson.
Aye.
4 ayes, 1 excused.
Okay, and I'll obviously floor manage that. All right, thank you, Senator Craigo. We'll move to our last bill. And Senate File 9, Restoration of Rights Amendments. Senator Craigo, can you introduce the bill to us?
Thank you, Mr. Chairman. Senate File 9, Restoration of Rights Amendments. And this was a bill we worked over the interim in the Judiciary Committee, obviously, and really, 2 years ago, we passed a Restoration of Rights bill through the legislature. And since that time, we've discovered a few issues. Part of this is cleanup, and obviously we'll get the director up here at some point to get into some of those specifics. But one of the issues we were dealing with in particular was the restoration of firearms rights. And we were having issues as originally drafted, that bill language, that law allowed for the restoration of rights of firearms convictions from other states or for federal law. And we started running into problems with that. And the original intent of this whole discussion was to remedy that. There was some other minor things that I'll let the director talk about. But that was the main thing in this bill. And so a lot of this is just, you know, adding to the existing language. We created 2 new subsections, which is really the heart of the bill. And if you go to the end, on page 7, sections H and J were really the heart of the bill. The rest of the bill is really creating conforming amendments to adopt in H and J. And so H just clarifies that if you are convicted of another felony following yours being presented with a certificate by the department, that certificate is null and void after that, and you cannot use it for restoration of rights. And J talks about who or what types of crimes are eligible for restoration, which little I is under subsection A of the section. If the person was convicted of a felony under the laws of the state of Wyoming, subsection A are those rights granted back by the governor or the governor's office. 2, little I, B, C, and F, those are the rights that can be granted back to you by the department. And so those are non-violent felonies that occurred or were related to a violation of the state of Wyoming. And then this is the part where I think we want to get into some discussion. If you look on page 8, section 2, on line 13, it repeals 713-105 C2. And that was the provision that was talking about convictions of other state laws similar to ours or of other federal crimes similar to ours. As this is written, we can know the department, this is my understanding of it, could no longer restore voting rights for convictions out of other states. I'm not sure that's what we were intending to do. I know we were trying to address the firearms issue, and so I'd, at some point love to get the director up here and hear his take on that. But that's essentially the bill, Mr. Chairman.
Senator Crum, any questions for Senator Craigo?
Not at this time.
Okay. Then we'll move into public comment. We'll start with our director, Department of Corrections. Welcome. We know you, but please introduce yourself for the record.
Thank you, Mr. Chairman, committee members. I'm Dan Shannon with the Department of Corrections. Thanks for having me here today. Mr. Chairman, committee, if I just could discuss a few matters. As Senator Craigo spoke of, we worked this matter through the interim of the last judiciary, this past recent committee, and the main issue, excluding the cleanup language, was providing opportunities for those who are out of state, as well as with federal convictions, to receive a restoration of rights. The issues within the department, and I also believe for our citizens who have had their rights restored, that's really created some issues. It was more operational. The cleanup language was ATF. They expanded their name to add explosives. DCI to be notified. There was one portion of the bill, and I can go through the bill briefly. Eligible voters, and I can provide a few numbers to the committee. In reference to that you have to be eligible to vote, that's another way of saying you're a U.S. citizen, because we have additional language in our laws that require that citizenship for vote. So in reality, a non-citizen could apply for the restoration of rights. With that being said, and to simplify things, in 2017, July 1st of 2017, individuals were given their right for the vote back. And that went back to July 1st of 2010. In July 1st of 23, the additional rights for right for juror, right for voting, right for firearms, things of that nature was granted. Since such time, we have restored 4,454 rights to vote. With that being said, since July 1st of 23, 1,060 individuals have received their other rights. But in reference, Mr. Chairman, in reference to what Senator Craigo was discussing, 63 individuals, these folks were from federal court convictions within the state of Wyoming. Those individuals living in Wyoming without a state convictions was 67, and surprisingly, living out of state with Wyoming convictions is 156. So we have more individuals living out of Wyoming with those convictions. And we also have 3 individuals that we had to grant a right to that were not Wyoming convictions nor Wyoming citizens. So an example, an individual from Ohio could apply in Wyoming for whatever reason, maybe come to elk hunt or whatever it may be. And I don't think that's the real intent, because what we tried to work at was to eliminate the federal convictions as well as out of state and really bring it around to the Wyoming convictions. Those are the ones we want to address. And if we could start, and if I may do it briefly, on page 2 and 3, there's additional language referring to subsections H and J, as our Senator Crago spoke of. These subsections really are new sections that bring it back. On page 2, lines 18 and 19, which removes the language under the laws of the states of the United States. So the bill can be amended later only to Wyoming convictions. On page 3, lines 13 through 16, and language that indicates must be eligible to vote, as I mentioned earlier. What that does is clean up to say that you have to be a citizen to apply. On page 4, lines 14 and 15 provide a cleanup of language to encompassing voters and other rights. When the bill initially took place in 2017, there was never mention that if you lost your rights or you committed another felony or in violation, that it was automated. It was with the July 1st to 23 bill. With that being said, so it was not an automatic removal for voting rights, but it was an automatic removal for the other rights. And what that does is clarify in this bill that if you violate these rights and commit another felony, that these rights are automatically null pros and left alone. The rest of the corrections on page 4 are cleanup amendments. On page 5, lines 10 through 12 is cleanup language, removing offenses committed in other jurisdictions which allow Wyoming only offenses later in the bill. On page 5, lines 16 and 17 under section F, H, and J have been added to encompass voter and other rights, and that's making reference to what I just spoke of. Page 6, lines 20 through 22 is cleanup language regarding notification for ATF to also add the word explosive. On page 7, lines 4 and 5, Department of Division of Criminal Investigations is cleanup language for DCI to be notified. On page 7, lines 7 through 13 is a new section. Section H indicates that if you're convicted of a new felony, the certificate is void and all rights previously restored will no longer be deemed under that restoration. And on page 7, lines 15 through 23, and page 8, lines 1 through 3 is a new section. That's section J that we spoke of earlier. And that's someone who's only been convicted under the laws of the state of Wyoming is eligible to have their rights restored. Real briefly, I just want to comment, and I know we'll get to our work. As of, it's relatively new, but this program I believe has been very successful. As of July 1, 23, of the 1,070 certificates we issued, we've only had 3 individuals in Wyoming be rearrested. And to me, that's exceptional. Looking back, we went back to 2010. Of the 4,000 certificates we restored for the voting rights, 286 were rearrested, or 7.5%. That's telling us that 92.5 people out of 100 are not being rearrested after 14 years. And for that, we can create less victims, and that's what we stand for. Mr. Chairman, I'll stand for questions.
Senator Craig.
Thank you, Mr. Chairman. Director, so prior to 2023, if someone was convicted of a nonviolent felony in one of the neighboring states, could they or could they not apply for restoration of their voting rights in Wyoming?
Director Shannon.
Mr. Chairman, Senator Crago, they could apply for restoration of voting rights specifically in Wyoming. That's correct.
Senator Craig, any follow-up? Crum.
Mr. Chairman, Mr. Director, is any problems that you see with the proposed language that you know, as far as administration or, I know you mentioned the numbers about the rearrest, but anything else that would be a concern to you on this?
Director Shannon.
Mr. Chairman, Senator Crum, Senator, no. I think we're going a long way around to say that it's Wyoming only votes. I mean, Wyoming only convictions first time it meets the criteria. As far as operationally, no.
Senator Craigo.
And I don't, Director, Mr. Chairman, I don't remember what the exact testimony. Again, I missed one of our first meetings when we talked about the basics of some of this, but remind me again why because essentially now we're saying there will be no restoration of voting rights. I mean, I understood the conversation regarding the firearms convictions, but there will be no Wyoming restoration of voting rights for convictions outside the state of Wyoming under this proposed language. And can you remind us or tell us why we're changing that portion in particular?
Director Shannon.
Mr. Chairman, Senator Craigo, I believe it was more of a cleanup in their reference. These would be individuals convicted in another state now coming in. And if you looked at statistics, it's very few individuals from other, as a matter of fact, I think it was 63 in the past years that have applied. The example is you were convicted of a crime, say in Deadwood in South Dakota, and you return back to our state. And can you apply for your voting rights? The concern that I brought before the committee, and Mr. Chairman, Senator Craigo, and the concern that I brought before the committee was based upon the other rights, especially those under federal convictions. We as a department, to answer Senator Crum's question about operationally, we as a department place it on the certificate in red. We put it on our websites, we put it on our applications, saying that you need to seek counsel if you're under one of these, convicted under one of these federal offenses, because it's questionable. From a department standpoint, Mr. Chairman, Senator Craigo, while I will not make a recommendation on policy, I certainly don't have any concerns if the individual, if it, under our voting rights, was from another state and they resided. It does put the department in a bad situation. Now we have to determine citizenship and or residency. And I think we're going down another rabbit hole there.
Other questions for Director Shannon? All right. Thank you.
Thank you, Mr. Chairman.
Any other agencies wishing to testify on this bill? If not, we'll move into general public comment. Mr. Lindholm, welcome.
Mr. Chairman, thank you for the opportunity. My name is Tyler Lindholm. I'm the State Director for Americans for Prosperity here in the state of Wyoming. We're on and neutral on this legislation. Our current viewpoint is on this legislation has to do with the fact that the current legislation that we have works very well, minus the problems that we're seeing with the gun situation. And it would be our opinion and urge to keep finding a way to fix that situation. We believe the repealer that's in the legislation is heavy-handed and has unintended consequences, and it would be the request that you delete that repealer and work to find a way, and we'd be happy to work with the members, Mr. Chairman, and yourself on finding appropriate language to fix that situation. We just heard testimony from the department that specifically, pardon me, that specifically cited 63 out-of-state felonies that Wyoming was able to essentially fix for Wyoming citizens. That's not a huge situation, I suspect, in areas like Casper or Lander or anything like that. Mr. Chairman, members of the committee, my community borders along South Dakota, and what we end up seeing is we see a lot of folks from Little Old Crook County, Wyoming, find themselves in a little bit of trouble in the bigger city of Rapid City, South Dakota, making a big screw up. 20 years later, this comes along. And I myself have helped someone from my community restore their rights thanks to this legislation being in place. And certainly their felony existed in South Dakota. That individual, without your work that you put in, would still not have his rights. And it was a shock to him that he could even get his rights back, and it was a pleasant surprise. But with that repealer in place, he would have not been able to get his rights back. And he's a Wyoming citizen, has lived here his whole life. Obviously took a road trip a long time ago and made some bad decisions. That being said, that isn't a very effective piece. Only 63 essentially was said, and I guess I can't, even if it was just one person got their rights back, that's a really good deal. So while it is a smaller number than I think I heard the number for over 4,000 that we've been able to help in the state of Wyoming, which is tremendous. Those 63 are still very important. So I would ask the committee to give some time and effort towards finding a fix besides repealing the provision that helps these out-of-state felonies. With that, I'll stand for questions.
Thank you, Mr. Lindholm. I wasn't there during the interim, so I'm not privy to I guess, the discussion on the genesis of this bill, but at least for the 68th Senate Judiciary Committee, I don't think that our intent is to put forward legislation that would prohibit a person who is convicted out of state from being able to then restore their rights once they relocate or locate to Wyoming. I agree with you on that. So something we're gonna have to work through. I think that's done, just so I understand it right, that's done in the repealer of section 2, right?
Mr. Chairman, to my understanding, yes. And that's kind of where the rub exists, is the committee's work was to try to fix this gun situation that's currently happening. While we were sitting in the back, Mr. Chairman, and members of the committees, I was able to start texting our U.S. senators and congressmen that there is this huge issue. And obviously Congress is pretty incompetent, so they're probably not going to be able to get anything done. Our members are great. It's the other 434 members of the House and 98 members of the Senate that are the problem. That being said, it's obviously a federal situation that needs to be fixed, at the very least, where the ATF needs to know if these people are on this list in the state of Wyoming, you need not break into their house in the middle of the morning and serve them with a search warrant and drag them out in the early morning, as we just saw in the press.
Mm-hmm. Questions for Mr. Lindholm? No? All right.
Thank you, Mr. Chairman.
Thank you. Director Shannon, did you want to add to that discussion?
Mr. Chairman, committee members, once again, I'm Dan Shannon from Department of Corrections. We certainly, I'll certainly comply with whatever the committee and our legislative body directs. Voting rights, to me, which would be section F, is much different than the other rights. When you're looking at the other rights from out of state, we have to do comparatives. We have to do we as the department have to do comparatives for the type of crime, the type of sentence. You would have individuals moving. You potentially could have individuals moving into Wyoming that have committed, crimes in other states that we're uncertain of the comparatives. I ran that through the AG's office. It's one thing to say, did I lose my voting rights? I went to South Dakota for the weekend. And I certainly don't have, I support it because I believe it makes better, I think it helps for our citizens in our state. But if we're having them come from Ohio and then they've committed a crime, now we're issuing our weapons. Are we going down, I would ask the committee in a question format, are we going down the same pathway as we are with our federal regarding the other rights, which would be section H of the bill?
Senator Crago.
I just wanted to comment that I actually agree with the director. I mean, I think my whole question was separating out the voting versus the firearms rights. And I think that's where the delineator is for me. in particular, because I think we're just gonna get into all sorts of issues, whether it's other states' laws or the federal laws. I think we're gonna get into issues when we start talking about the gun rights. I was just worried about the voting rights, and when I was talking about the bill early on, that's really what I'm concerned about. I mean, I'm happy to spend some time, dig back into this, and to be honest with you, I'm apologize to the committee that I did not do it sooner during the interim and should have caught some of that, and we worked it, and I think lots of us were still confused, even though we worked it all summer, and so for that, I'm sorry, but I'm happy to try to work on that, and maybe I can spend some time with the director and try to figure out a way to do that.
Mr. Chairman, Senator Craig, absolutely.
All right,
Thank you for allowing me to speak.
I like it. Nothing like fixing legislation when we're down here in session, other than fixing the interim work. I guess it happens. Any other public testimony? Yes.
Thank you, committee and Chairman. My name's Marguerite Herman. I'm here for the League of Women Voters, and I also sort of apologize for not being more involved in this in the interim, but the League of Women Voters firmly believes that supports the decision for the automatic renewal of voting rights with the single felony, nonviolent, and anything you can do to preserve it while you separate out the much different issue. I agree with Senator Crago that firearms are a different question, but and I would hate to see the voting right restoration somehow diminished in the process of taking up the other part. And it sounds like that, if it's happening, that's inadvertent, and so anything you can do to rectify that, I'd sure appreciate it. I guess if and I think the big progress we've made in recent years is the automatic restoration. If it can't be automatic, maybe by simple application and an easy review of the details, and then the granting of that might be a way around it. But anything you can do to restore that, because as the director said, restoration, participation in your government is a really strong impetus for staying out of trouble and avoiding recidivism. Thank you.
Questions for Ms. Herman? All right, thank you. Any other public testimony? Any testimony online? All right, with that, I will close public testimony. And I think committee, what I would prefer to do is to lay this bill back until our next meeting and work on the language between now and then, because the bill in its entirety isn't doing what we thought it to be doing, what we want it to be doing necessarily. So I don't feel comfortable moving it forward as is. So
That would be great. Thank you, Mr. Chairman.
all right, absent objection, this Senate File 9 will be laid back until our next meeting, regularly scheduled meeting. Thursday, yeah. Thursday the what? 23rd. Thursday the 23rd, we will take up Senate File 9 once again. And with that, we are adjourned. Thank you. Now you can go eat lunch, if you didn't eat lunch. Senator Crago.
Yeah.